Welcome to Adam Bernards Podcast. Joining me today is Fauzia Azim, Head of Legal Operations at Adam Bernards Solicitors. It's brilliant to have you today, Fauzia. Let's set the scene. Because a lot of our listeners will hear of EB1 and National Interest Waiver and immediately think that's not for me. Why should I keep on listening?
Thank you, Luke, for the question. It's a very interesting question. Most people, they underestimate themselves. They think that they do not qualify for the EB2 National Interest Waiver or the Exceptional Talent Visa. However, this is untrue. If a proper profile evaluation is conducted, let's say you needn't be someone like a tech Silicon Valley giant, or let's say you are extraordinary researcher who's published like too many papers. No, the criteria is quite comprehensive, but however, upon doing a detailed profile evaluation, you might be surprised that you might meet the criteria as well, and it's the best route for a green card.
So, just to make sure everyone's following, when we talk about EB1 and EB2 National Interest Waivers, these are self-petition routes, aren't they? You don't necessarily have to have a US employer to sponsor you.
That's the main attractive part of these petitions, that your status is not tied to an employer, unlike the non-immigrant petitions like H1B or O1, where your status is always at a risk, or it's in jeopardy. If you lose your employment, that means your status is lost and you would need to find a new employer. So that's the main attractive part of EB applications, I would say, petitions or applications.
Okay, perfect. And that's exactly why these routes have become so attractive post-pandemic. Job security has taken on a completely different meaning for a lot of people. Now, the big news, the US Department of Homeland Security has put forward some proposed regulations that would modernize and tighten the criteria for both routes. When you first read these proposals, what was your immediate reaction?
Well, of course, yes, they tightened the scrutiny of adjudicating these applications. My first reaction was how they differentiated between the poorly structured submissions versus organized applications or petitions. So I must say the landscape has shifted, where USCIS is expecting the applicants to submit well-structured evidence and detailed supporting letter, in contrast to the previous petitions back in the 90s. They do not want generic information. They want the information that's tied to their profession, that's tied to their achievements. So yeah, we have processed a large number of these type of cases recently and been successful to most of the applicants who come under the category or the area of outstanding researchers, or they might be fintech professionals, business owners. So it's very, very important to structure the petition carefully before submitting. This is where most applications fail, because they just go with the generic immigration advice, and this is one of the most common reasons for denial.
Let's pack the EB1 first. Historically, extraordinary ability sounds like it's reserved for Nobel laureates and Olympic athletes. But that's not quite right, is it? Who genuinely qualifies?
Right, for EB1, as EB says, it's employment based. The EB1 is for extraordinary ability or talented people. They might be in any field, as long as they have risen to the top percentage in their field. So, to answer your question, most likely what they look is for people who qualify the legal standard. For EB1, there is a set standard. So out of 10 criteria, if you meet 3, then yes, of course, you qualify to apply for an EB1. Now, when you say you do meet the 3 criteria, it's not just merely by saying, yes, I have achieved this, yes, I have done that. You need to back it up with clear evidence as well. So whether you are an exceptionally talented researcher or in the STEM field, or an AI scientist or a data scientist or even a business owner who have successfully launched the businesses, they will still be applicable or be eligible to apply.
Okay, perfect. Thank you. So, under the new proposed standards, what's actually changing? Are the goalposts moving, and if so, in which direction?
That's a good question, Luke. So the goalposts are not changing massively, but however, what the USCIS are concerned about is criterion stuffing.
Okay.
So what people do, or the applicants file their cases by stuffing in the criterion without proper structuring, like I explained. Let's say if they nearly meet one criteria for published work in the media, if the media is not of a recognized standard, the USCIS is coming back and questioning that the applicant has not met this criteria. So it's very imperative to understand that you cannot stuff in your achievements with the criteria, and a detailed profile assessment needs to be conducted to know which criteria you nearly meet, you potentially meet, and you have strongly met.
Perfect. Thank you. So let's get to the national interest waivers under EB2. This one feels less about personal prestige and more about what you're contributing, right?
Yes, national interest waivers, the term itself says your contributions must be of a national interest to the United States. So typically the United States Homeland Security, or the DHS, Department of Homeland Security, what they look here is the three-prong criteria called under the matter of Thanissar. So the three-prong meaning your achievements must have been of a substantial merit or must meet the substantial merit criteria. The second being your achievements must be tied to the national interest to the US. Let's say you are in the telecom industry and you have achieved quite a lot in establishing communicative devices in rural areas. So you would need to say that, yes, it will be of national interest to the US. In certain states, certain technologies are in demand, and it is required to uplift the economic activities or economic situation seen in that state. So we must establish that the profession is of national interest to the US, and the third criterion being to waiver of the job requirement because the profession is of national interest.
Okay, perfect. Thank you. So, under the 2026 proposals, how is national interest being redefined? Because I imagine that phrase can mean different things, especially depending on the political climate.
Well, honestly, Luke, step one must be conducting an honest eligibility requirement or assessment. That's always the foundation to an approval of these kind of petitions. So step one, not just by ticking off certain checkboxes, but conducting a detailed assessment. At Adam Bernards, we do provide with detailed profile assessments. We understand the applicant's background, and we also evaluate their achievements, what they have achieved. Let's say, for example, they have led the role of a leadership role in a company, worked for distinguished organizations, published articles, have held memberships, or have gained high salary. So we look into each criteria in depth and assess whether they can provide the evidence that can support these criteria as well. So discuss, have a one-to-one consultation with the applicant and give them like a roadmap on how the application is going to structure, give them a strategy. The second step is drafting. Once we get on with the initial draft, we share it with the applicants or our clients, and upon review, they will give us a green signal like, yes, let's proceed for the USCIS filing, and step 3 is the USCIS filing.
Okay, perfect. So that now brings me to timelines. These are not quick routes, are they? What should someone realistically plan for?
Transparency is really important here. Let's say for filing the petition, the form I-140, if it's not premium process, it can take up to 8 months. Yeah, so we always advise our clients to go with a premium processing filing, which can shorten the time frame up to 15 to 45 days. It depends based on each petition filings. So 15 days is the shortest time. The petition can be approved, so that can quicken the process quite a lot.
Thank you. And the role of a solicitor in all this, I imagine some people listening thinking, I'm intelligent, I'm accomplished, I've read the guidance, surely I can do this myself. Can they?
Well, I must say that a couple of YouTubers and people who doesn't have much experience dealing with these kind of petitions do set up propaganda online that it is quite easy to do, but honestly, no, it's similar to submitting a research proposal, if I'm being very honest. We spend hours and hours on extensive legal drafts here, have back-to-back meetings with the clients. Even we draft templates of expert opinion letters, personal statements on behalf of the clients. So we do a lot of hand-holding with our client, and it is not an easy type of visa to be done by yourself. Definitely not a DIY. Look, I can assure you that having a legal help will massively help, especially in terms of getting an approval, and having an attorney and a law firm hold your hand is really important for these kind of petitions.
Yeah, perfect. So we're seeing reports from law firms and employer groups, especially in this year 2026, of the heightened security around employment-based immigration broadly. Does this change your advice to clients who thinking about waiting or maybe hoping to settle down?
I would say underestimating their profile. When they hear the words like Nobel having had to win Nobel Prize, Peace Prize, or a prize, they might think the criteria is quite high and they would not meet. However, they do not know if you do not meet one criteria of having won a Nobel Prize, there are other criteria out of 10 which you need to meet the 3. So it's either or that. People generally underestimate their achievements. It's always best to speak to an attorney, to a law firm, and get the right guidance at the right time.
Thank you again so much for your time, Fauzia. I've been Luke, and this has been Adam Bernards Podcast at Adam Bernards Solicitors. We'll see you again.